a Colorado Rules of Evidence overview. I'm going to do a quick Colorado Rules of Evidence overview. So CRE. Let's talk about CRE. Now we have Article 1, Article 2, Article 3, Article 4, 5, 6, 7, 8, 9, 10, and 11. There's 11 articles. Within each one of the articles, Article 1 has 100, Article 2, 200s, Article 3, 300s, on to Article 11 to the 1100s. So it'll start out Article 5, and then it'll have 501, 502, Article 6, 601, 602, 603. Now, overall, let's just read the titles and then read how many rules there are. Starting from Article 11, this is miscellaneous rules. So we got some miscellaneous rules. Article 10, they're talking about writings, recordings, and photographs. Article 9, authentication and identification. What's the requirement of authentication or identification? Hearsay. Let's get into hearsay. Hearsay exceptions, residual exception, definitions. Article 7, opinions and expert testimony. Opinion testimony by lay witnesses, testimony by experts, basis of opinion testimony by experts. Article 6, witnesses. You want to talk about witnesses? Somebody was asking about privileges. That's Article 5. You want to know about privileges? Read Article 5. That's Rule 501 and Rule 502. Now, Article 6, witnesses, it goes all the way to Rule 615. Exclusion of witnesses. Something about religious beliefs or opinions, competency of judge as witness. Article 4, relevancy and its limits. Rule 401, 402, 4 all the way to 411, liability insurance. Relevancy. And in general, relevant evidence is generally admissible. Irrelevant evidence, not admissible. Article 3 is presumption in civil actions and proceedings. Judicial notice is Article 2, Rule 201, the judicial notice of adjudicative facts. And then general provisions is the scope, purpose, and construction rulings on evidence, preliminary questions, limited admissibility, remainder of or related writings or recorded statements. And that's it. That's it. The rules of evidence are the product of 6 years of work by a select committee of the Colorado Bar Association, chaired by Professor Francis W. Jamison. The rules parallel the federal rules of evidence and the uniform rules of evidence promulgated by the National Conference of Commissioners on Uniform State Laws. The drafting committee submitted the proposed rules to the Colorado Supreme Court and assisted in the presentation and complete review of the rules at 3 public hearings. So I don't want to talk about any of these specific ones. There's the relevant evidence, I think, was pretty interesting, right? Methods of proven character, compromise and offers to compromise, payment of medical and similar expenses, offer to plead guilty, nolo contendere, withdrawn pleas of guilty. Witnesses. Evidence of character and conduct of witness. What do I want to say about any of this? I don't know. Let's just start with this page here. Rule 301, presumption in general in civil actions and proceedings. In all civil actions and proceedings not otherwise provided for by statute or by these rules, a presumption imposes upon the party against whom is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift to such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. This rule is essentially identical to the federal rule, thus achieving a desirable degree of uniformity and simplicity. It gives all the proper traditional benefits of the presumption, but places no new burdens on the opposing party. So be fair. Is that what you're trying to say? Be fair. The doctrine of res ipsa loquitur no longer creates a presumption of negligence, which shifts the burden of disproving the presumed fact of negligence to the opponent of the presumption. The doctrine only shifts the burden of going forward with evidence to rebut the presumed fact of. There you go. as clear as mud. Definition of relevant evidence. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Tendency to make the existence of the fact that's of consequence to the determination of the action more or less probable. So are we getting closer and closer to the truth? Is that what they're trying to say? So it sounds like a tendency to make the existence of any fact come to light. And the federal rule is identical. There's no qualitative difference between direct and circumstantial evidence. No qualitative difference between direct and circumstantial evidence. What? People in interest of MSH. Colo 1983. Test for determining relevancy of real evidence is that such evidence must only be connected in some manner with either the perpetrator, the victim, or the crime. People in interest of RG. Colo Appeals 1981. Relevant evidence generally admissible. All relevant evidence is admissible except as otherwise provided by the Constitution of the U.S. or Colorado, by these rules or by other rules prescribed by the Supreme Court or by the statutes of the state of Colorado. Evidence which is not relevant is not admissible. So that's the bare standard, right? Is that evidence relevant or is it irrelevant? If it's relevant, then we need to keep it. If it's irrelevant, then throw it out. The trial court's discretion to determine relevancy is broad. What? That's a smoking gun? We don't need that evidence. You have a videotape of a smoking gun? But that's of my buddy. That's of my buddy. I don't want you to show that. No, that is not admissible. Let's just read something right here. Rule 403. No, I want to read 607. What is Rule 607? You got interpreters, oath or affirmation. Rule 606. Rule 608. Shoplifting. It's a specific instance of conduct that's prohibited of truthfulness pursuant. Probative. That is probative of truthfulness. What are you trying to say to me? Rule 607, who can impeach? The credibility of the witness can be attacked by either party, so the defense or the prosecution can try to ask leading questions to attack the character of the witness, to try to impeach him.